Hello, and welcome to the November 2023 issue of the Zavitz and Sykora Financial Strategies video newsletter. Thank you for tuning in and listening to our update. I'm your advisor, Greg Sykora, and joined with me here is Mark Zavitz. Today, we're going to go over what's happened regarding portfolio performance in the past month, the very nice rebound that we've seen. And then we're going to talk to you about what happens if you die without a will in Ontario and the implications it can have on your loved ones, and of course, urge you to have wills drawn and updated. So, this is a review of last month's performance, and as you can see here, on a year-to-date basis, our very conservative, moderate growth, and growth portfolios had around a 2% return, and so performance wasn't too good last month or finishing last month. However, as you can see here, just moving around 30 days that we've seen a huge rebound in performance. Most of that comes on the backs of around a 3 to 4% movement in the valuation of bonds as yields have come down. And that's mostly because there's been surprise downsides to inflation numbers that have come out. So that's good. I mean, inflation's coming down, and stocks have rebounded to the tune of around 6, 7, 8%, depending on the markets. And that's why we've seen such a large jump in performance for the growth portfolio. So on a year-to-date basis, our very conservative portfolio is up around 5.5%. Our conservative portfolio is up around 6.5%. Our moderate portfolio is up around 8%, and our growth portfolio is up almost 10%. Now to speak about what happens if you die without a will. First off, when you die without a will, it's called dying intestate. So if you ever see the word intestate anywhere, it simply just means dying without leaving a valid will behind. When that happens, the government decides using provincial laws how your estate gets distributed. The estate then goes to the provincial courts, and where it can be held up for several months by the courts as they appoint a court appointee. A court appointee or a trustee will then look to bring in a family member, such as a surviving spouse, or perhaps children or a sibling, to then act as the executor of the estate. But again, the entire process can take several drawn out months, can lead to a high amount of fees and costs, and essentially, as it plays out, can lead to, an estate taking or drawing out, months longer than it essentially needs to. So the most important thing is what happens to your assets when you die without a will, when you die intestate. Well, to the surprise of many, they don't just roll over to a spouse. No, in fact, if there are kids involved, if you have kids, they would also be in line to receive a chunk of the value of your estate. And I know that comes as a surprise to many. And that's why it's crucial that you have a will. I found this great diagram online from Epilogue Wills that describes what happens if you die without a will in Ontario. To most people's surprise, if you die without a will in Ontario and you have a surviving spouse as well as children, your estate, again, doesn't just roll over to your spouse. The estate gets split between the children and the spouse. Now, if you think about that for a moment, this could lead to minors, your children, if they're minors, receiving a large inheritance that you didn't intend for them to receive. And in some cases, if they are minors, they would need to have trusts set up for them, which leads to, costs and fees. Or worse, for your surviving spouse, I mean, of course, if you love her or love him, it could lead to your surviving spouse being without enough money to survive, which, of course, we want to try to avoid. Another stipulation is the fact that the first $350,000 of the value of your estate goes to the surviving spouse before there's a split of assets of the remaining value of your estate. So here's how that plays out for someone who dies intestate with $1 million value in their estate. So in this case, where there's a surviving spouse and two children, the assets would get split as follows. The first $350,000 goes to the surviving spouse, which leaves $650,000 in the estate to get split three ways between the spouse and the two remaining children. Now, if there is no spouse and there are no children, then the surviving parents would be the ones to receive the value of the estate. And so the $1 million would get split between both parents. Of course, if there are no parents, then the surviving siblings are the ones to receive the value of the estate. Then if there are no siblings, it then goes to nieces and nephews. And then if there are no nieces and nephews, then it goes to blood relatives. And I know many countries actually follow something similar. The States follows a similar order for who receives the value of the estate if you die without a will. And so, if you've seen it in the movies, of course, it is possible for you to receive a large inheritance from your blood relative, your great Aunt Gladys, who's somewhere in Europe, if you are the surviving, sibling or surviving blood relative of that individual. It does happen. Of course, the order of which the estate gets distributed would then be followed. But if you're the only surviving person in that family, hey, maybe you would be in line for a nice windfall. Mark, you've witnessed before how this can play out. Talk to me about how that's played out in your family.
Well, Greg, my wife Sue, her stepbrother passed about 5 years ago, for just before the pandemic, actually, and he died intestate. He lived in Coburg, so he lived in Ontario, Coburg, Ontario. So he was very close. He had two sisters that he was very close to, and then he had my wife Sue was a stepsister. He was reasonably close with her, but had no contact at all with Sue's natural brother Paul. And so unfortunately he died intestate, and so all four of them got a quarter of his estate. And I'm certain that he would not have wanted his stepbrother Paul to get any. But having said that, it caused some animosity, and it also caused, Greg, the pandemic may have had something to do with this, but it took over a year to get one of the sisters designated as the court-appointed administrator or executor, because there was no will and no executor. The lawyers sent 10 or 15 letters back and forth. The legal fees were thousands of dollars higher. So it was really, really unfortunate. It took a couple, 2-3 years to settle the estate. Cost, my best guess, was I was exaggerating, is $5,000 to $10,000 more in legal fees for all the documentation. And
Jeez.
No one, and the beneficiaries, A, didn't have access to the capital for 2 or 3 years, but B, it probably didn't go the way he wanted it to.
Yeah. I guess that's the most important thing. But yeah, it's brutal, the fees that can be charged and accrued over time, but just legal fees and sending those letters. And of course, everything gets drawn out. Absolutely awful. So of course, if you don't have a will and you're watching this video, we urge you to get something in place so that whoever it is that eventually becomes the executor or executrix of your estates doesn't have to go through all the headache. So most of the laws surrounding like disbursement of estates, they don't really change. The amount that goes to a surviving spouse, that $350,000 amount that we just spoke about, that's been adjusted a few times over the past few years, and it gets revised upwards over time. But when it comes to the order and who receives the estate, that hasn't changed for some time. It used to be common practice for when you got married that you would also need to rewrite your will. Because what would happen is if you got married, say a second marriage or third marriage, your new marriage would revoke your previously written will. And what was happening was essentially that someone get married a second or third time, their previous will would get contested because the new surviving spouse would want claim over some of these assets, and the person would in essence die almost like intestate. because the previous will would be revoked and nullified. Of course, that would take months or even years to play out. Anyone who was a potential stakeholder would be contesting it, and you would just have these long, drawn out legal battles. So then the province of Ontario and several other provinces as well decided to change the rules. And so if you get married, your previously written will no longer gets revoked. And that was changed in 2022. All this means is that if you are part of a second or perhaps a third marriage, that it's definitely important that you revise your will to make sure that your estate gets dispersed in the way you want it to, and so that it doesn't, in essence, unless you want it to, get dispersed to your previous spouse, and it doesn't go to their family, et cetera, et cetera, et cetera. And so there are some ways to make sure that your assets don't flow through your estate. They don't get dispersed, doesn't get dispersed in accordance with what's in your will. Any of your assets that have named beneficiaries or are held in trust, so if they're held in, say, like an RRSP or RIF or a TFSA, they're not going to flow through your estate. So whatever's in your will is not going to matter. Mark, maybe talk a little bit about some of the conflict that can come from having a named beneficiary and then naming beneficiaries in your will if they don't necessarily line up.
Yeah, sure, Greg. From the top left of the screen, you see some of the different contracts: registered retirement savings plans, first-time home savings accounts, tax-free savings accounts, registered education savings plans. There's also life income funds. There's RIFs, registered retirement income funds. So these contracts can all have beneficiaries in the application. When you're setting up these contracts with your financial advisor, one of the questions is, do you want to name, in the event of your death, where do you want the money to go? Do you want it to go to your spouse or your kids, or do you want to name your estate as beneficiary? So everyone has the ability with most of the investment contracts to name a beneficiary, and that designation is what will direct where the funds go. So it will supersede the will. So in the event of death, if you name your spouse, the funds go to your spouse outside the estate quickly. If you name your estate, of course, the funds will go to your estate. Now, when you're drafting your will, you just need to be careful to be consistent with, either you don't need to say anything. If you've handled everything with your RSP and your tax-free investment account, you've named all the beneficiaries, it's all set up, then there's no need to name that in your will. But some people, are very thorough, and they start naming where the funds go for all their assets in their will. And if that's not the same as the beneficiary designations in the contracts, then there could be some conflict. So just be careful, be consistent. And but I guess the point is that if you name beneficiaries in your investment contracts, then you've taken care of that in the event of death. That'll all be taken care of outside the estate quite quickly and efficiently. And anything that's left where there are no beneficiaries will flow into your estate. And then as long as you have a will, well, even if you don't, as Greg just mentioned, you do have a will. You die intestate, you have an Ontario will here in Ontario. But in the event that there are no beneficiaries, the funds will flow into the state and then and to be distributed based on your will.
Yeah, thanks, Mark. So when it comes to your estate, I'm going to urge you not to use some of the online services, although they are getting better. To set up a will or to draft a will. In most cases, it's worth it to speak to a professional, because there could be the rules or nuances or something subjective that requires a lawyer's or an experienced notary's opinion or expert advice on. And when we're dealing with tens or hundreds or even hundreds of thousands or millions of dollars, of course, we don't want to leave any of that up for contention or anything. not to be executed in accordance with what you want to have happen. So our recommendation is, work with a lawyer in most cases, and get your will updated or drafted if you don't have one. Now, if perhaps you need some help there, or you don't have a lawyer, or it's been some time, we do have a professional working relationship with a lawyer group out of Niagara Falls. And if you would like a recommendation or referral, we can certainly put you in contact with them. Just let us know. And with that, I'm just going to end on the disclaimer. Just want to say thank you so much for tuning in and listening to our update. We hope you have happy holidays up ahead, and we look forward to presenting you with our next monthly update at the end of December. Thank you so much, and have a great month. Cheers.
Merry Christmas.